The Section 34 saga, well, has it come to an end? A new Justice Minister has been sworn in. As we continue to look at the healing process in the judiciary, the legal system and the legal fraternity, what's happening this morning? Joining us on set, a well-known attorney at law, Lalla. Mr. Lalla, good morning. Thank you for joining us.
Thank you very much for having me, Hema.
The unions continue to call for the resignation of Anand Ramlogan. The opposition even last night claimed that they will file a motion before the parliamentary chamber, a motion of censure. I think it's likened to a motion of no confidence in the Attorney General, saying he's not fit to hold office. Is the Attorney General guilty of any wrongdoing, in your opinion?
Well, I mean, before you come to a conclusion that the Attorney General is guilty of wrongdoing, you have to examine all the facts objectively and look to see whether there's any evidence to support that position. I have been looking in the press very keenly. Last night, I'm sure like most of the public, I was tuned into my radio, listening to the meeting in Aruca.
Right, with pt1.
And I was also tuned in at the same time to the television stations because you had all the politicians out. And in listening to the radio, I was hard-pressed to understand what was the evidence that the good leader of the opposition intended to rely upon. Number one, to call upon the Prime Minister to remove the Attorney General. And now, two, to go to Parliament to say that we should censor the Attorney General. I have not seen any evidence. All there is speculation. And if I might add, it is political speculation.
But then the timeline, everyone has been using that fat word recently to describe all of the events, saying the timeline makes no sense. And while the Prime Minister delivered a detailed address to the nation the night that she made the address, they're saying that while the Attorney General was out of the country, the filing of the various motions as it relates to the matters concerning these two financiers of the party, it simply makes no sense. They look at the timeline saying that everything doesn't add up.
Well, a couple of things. Number one, the Prime Minister, yes, she said that the Attorney General was out of the country at a certain point in time. I believe from July 20th to August the 4th. She made it quite clear that when the cabinet note came before Parliament on August the 6th for the early proclamation, the Attorney General was there. So she didn't say that he was not in the country at the time that the note was brought. And then you have the Prime Minister saying that as the head of the government, as the head of cabinet, she conducted an inquiry. She spoke to the Honorable Minister of Justice. She spoke to the Honorable Chief Justice. She spoke to the learned DPP. And having conducted her inquiries, she realized that there was one major area of concern. And that is that the Honorable Minister of Justice, as he then was, apparently misled cabinet. And that is what she acted upon. There was nothing to show that the Attorney General committed any wrong.
Al-Rawi says, as a Senator Al-Rawi, AG admitted he was not up to the job. The explanation given by Attorney General Anand Ramlogan that he is only versed in civil matters is weak and an embarrassment, says the PNM Senator. I have done a criminal case, save my first year in practice, for my years in practice, and I make that point. Although the Attorney General is the legal advisor to the Cabinet, when we created the Ministry of Justice, the criminal portfolio was assigned to that ministry, and the gazetted allocation of ministerial responsibility placed criminal legislation and reform of the criminal justice system under that particular ministry. That meant, therefore, that the staff with the expertise in criminal law will go to that ministry. So even the goodly senator is saying that the Attorney General is not fit for the job.
Well, I mean, a lot has been made in the press about the Attorney General's, the learned Attorney General's statement at the Industrial Court a couple of days ago. But frankly, I see nothing wrong with it. He was not saying that he knows nothing about criminal law. All lawyers know something about criminal law because criminal law forms one of your core courses at law school. But the fact of the matter is that throughout his many years in practice, he was not a criminal law attorney. Everyone knows that Anand Ramlogan was a public law attorney, that is, dealing with matters involving the Constitution, judicial review, etc. So when he says that he's not a criminal lawyer, he's speaking the truth.
But Mr. Lalla, if we look at this entire situation, people continue to attack the Office of the Attorney General, which the Prime Minister and the Office of the Attorney General constitute the government basically in our country according to our Constitution. If this office, do you think this office has been put into disrepute as a result of the actions committed over the last month or so?
No, because I see no evidence of that. All I see is political speculation. And the Prime Minister cannot act on political speculation. She has to protect her government. Further, the citizens of the country have a right. If the opposition is saying that the Attorney General ought to be disciplined, he ought to be removed, then we have to see the objective evidence upon which such a position is based. And when you look at the timeline, you look at everything that is out there, there is no objective evidence. All there is speculation. And we as a population deserve better than that.
Now, looking at the way forward, the opposition continues to press with this matter. They have gained support from the unions. The opposition is saying that they will not support any bills put forward by the government as a result of the actions of the Attorney General and the Prime Minister's inability to act on the Attorney General. How is it going to, what does it all mean for governance of our country?
Well, it's cause for serious concern because this government has, 2.5 years again in office. So if it means that we will not have any laws for the benefit of the population where a special majority is required, then that is cause for serious concern, and the opposition will have to make a determination whether they would like the country to be run in that way. It does not mean that the government will fall because they have a sufficient majority in the House to continue to maintain power. So it's entirely up to the opposition how they choose to treat with it. But again, we come back to ground level. What is the objective evidence of misconduct on the part of the Attorney General?
The Office of the Attorney General and that of the Office of the Justice Ministry, many in the population believe that Minister Volney, at that time, Minister Volney was simply the fall guy. In fact, he came out, a number of interviews were done after that, him saying that he offered his resignation. He was shocked when he heard that he was fired. All of the matters. And I think there was also a post on Facebook that I saw where he stated that the Prime Minister was indeed protecting Anand Ramlogan, who is a non-elected representative of the government.
Well, people are adopting that position because it makes for nice political bacchanal humor. But where's the evidence? The Prime Minister has said that she conducted her inquiry, and in that inquiry, the Honorable Minister of Justice admitted that he did not have the consent of the Honorable Chief Justice and the DPP to have the early proclamation of Section 34. So if that is the position, where are we going? What further evidence is going to come to light to show that the Attorney General did something wrong in the early proclamation of Section 34?
Why do you think that they are moved, or why do you think the Justice Minister moved to have, the then Justice Minister moved to have the early proclamation?
Well, he has put forward several reasons. The sections which were proclaimed early were sections 1, 2, 31, 32, and 34, as well as Schedule 6 of the Act. He indicated that we have to understand that act, the Indictable Offences Preliminary Inquiry Act, intended to effect a great and dramatic change in the way criminal matters were conducted, in that all preliminary matters were being moved, preliminary inquiries were being moved from the Magistrates' Court and going directly to the High Court.
Right.
In order to facilitate that, you needed to have a tremendous increase in resources at the High Court. You also needed to have the implementation of special rules. The Justice Minister indicated that the early proclamation of those sections were necessary in order to, 1, employ masters, 2, who would work the system, 2, in order to facilitate the promulgation of rules for the system to operate, and Section 32, which was proclaimed, deals with rules. And Section 34, which deals with the clearing of backlog, was also necessary in order to get rid of old cases so that when the new system falls on the High Court, it will not be too heavy a load for the High Court to bear.